Good day. I'm Mary Grace Galanida from BSHM3A, and today I am going to tackle the Chapter 4 of the legal aspects in tourism and hospitality, the laws on partnership and corporation. The tourism industry, being a high-level sector, must adhere to legal requirements to operate legitimately. Startups need a robust business organization for a strong foundation, making forming a partnership or a corporation a good choice, particularly for competitive industries like tourism. So, this chapter provides an overview of partnerships and corporations as business organizations. The law on partnership is regulated by the Civil Code of the Philippines, while the law on corporation comes under the Batas Pambansa bilang 68 Corporation Code of the Philippines. So here are our learning objectives. First, differentiate the various kinds of partnerships and corporations and the responsibilities of partners and incorporators. Second, identify the requirements in the formation and dissolution of partnerships and corporations. So now let's tackle about the law on partnership. So in the Article 1767, by the contract of partnership, two or more persons bind themselves to contribute money, property, or industry to a common fund with the intention of dividing the profits among themselves. So a partnership involves two or more people co-owning a business with the aiming of making a profit. So this definition includes religious associations, conjugal partnerships, and similar entities as they are not primarily profit-driven. A partnership contract is built on trust with a fiduciary relationship arising from the principles of the lactus personae, which stipulates that all partners must consent to the addition of a new partner. So here are the essential requisites of the partnership. It includes first, an agreement to contribute money, property, industry to a common fund. This is compiled with if each one of the partners brings or is obliged to bring something to the partnership, and that which is brought becomes common property. Second, intend to divide the profits among themselves. This is compiled with if partnership is established to obtain profit, profit must be common to all the parties, and profit or loss must be divided among the partners. So, the advantages of forming a partnership are easy to form, improved growth possibilities, and freedom from bureaucracy. And the disadvantages of forming a partnership are instability, difficulty in obtaining large sums of capital, firm is tied to the acts and judgment of one partner as agent, and difficulty in severing partnership ties. So here are the classification of partnerships. First, partnership according to subject matter. So A. Universal partnership is formed when all partners contribute their properties to a common fund for the purpose of obtaining profits as long as it is not against the law or public policy. However, it is rare to see business establishment forming universal partnerships nowadays. B. Particular partnership is formed when the partnership's objective is specific, such as the use of certain assets, a specific project, or the practice of a profession or vocation. And second, partnership according to liability. So we have a general partnership composed of general partners where liabilities extend to their personal properties. B. Limited partnership, one formed by two or more persons having as members one or more general partners and one or more limited partners, where the liability of the latter to third person is limited to their capital contribution. And lastly is the third, partnership according to duration. A. Partnership for a fixed term. So here are the obligations of the partners. So we have first, where contribution is money or property. This refers to the obligation of a partner to contribute financial resources or assets to the partnership as specified in the partnership agreement. Second, where contribution is industry. This refers to the obligation of a partner to contribute their skills, labor, or expertise to the partnership instead of monetary or property contribution. And third, obligation of the capitalist partner. The capitalist partner is obligated to provide financial capital to the partnership and may not be required to contribute industry or labor. And fourth, responsibility between partnership and partner. So partners have a mutual responsibility toward each other and the partnership, including acting in good faith, exercising reasonable care, and fulfilling their obligation as outlined in the partnership agreement. Fifth, sharing of profits and loss among partners. So partners agree to contribute profits and bear losses in accordance with the partnership agreement, typically based on the agreed upon sharing ratio or percentage. Sixth, property rights of the partner. So each partner has a right to use partnership property for partnership purposes but does not have individual ownership rights over the property. 7. Liability of individual partners to third persons. Partners are jointly and severally liable for the partnership's debt and obligations, meaning they can be held personally responsible for the partnership's liabilities. And lastly, liability of the limited partner. In a limited partnership, the liability of a limited partner is limited to the extent of their capital contribution, and they are not personally liable for the partnership's debt beyond that amount. So now let's jump to the dissolution and winding up of the partnership. So in Article 1830, dissolution and winding up of a partnership occur when the partnership ceases to exist and its affairs are concluded. So the law provides various circumstances that can lead to dissolution, including the expiration of the specific term or undertaking, the express will of the partner, the expulsion of the partner in accordance with the partnership agreement, contravention of the partnership agreement, legal restriction on the partnership's operation, loss of the specific contribution promised by the partner, death or insolvency of the partner, and civil interdiction. Additionally, a court may decree dissolution under certain circumstances. So, for example, a partnership formed between two friends to run a clothing store. After 5 years, they decide to dissolve the partnership due to their differing visions for the business future. So, they mutually agreed to end up the affairs of the partnership, settle outstanding debts, distribute assets, and officially close the business. So, this dissolution is based on the express will of the partners and the expiration of the partnership's term. However, Article 1831, it outlines the circumstances in which a court can decree the dissolution of a partnership upon application by or for a partner. So these circumstances include a partner being declared insane or of unsound mind, a partner becoming incapable of fulfilling their obligations, a partner engaging in conduct that adversely affect in the business, a partner willfully breaching the partnership agreement or conducting themselves in a way that makes partnership impractical, the partnership being operating at a continual loss, and other circumstances that render dissolution fair. So in these cases, the court has the authority to order the dissolution of the partnership. So for example, in a partnership between two individuals, one partner is consistently breaching the terms of the partnership agreement and conducting themselves in a manner that hinders the smooth operation of the business. So the other partner decides to apply to the court for dissolution based on Article 1831 of the law. So after reviewing the evidence and considering the circumstances, the court decrees the dissolution of the partnership, ending their business relationship. And now let's jump to the order of liquidation for a general partnership. So in Article 1839, after the dissolution of the general partnership, the process of settling accounts and liquidating assets follows specific rules outlined in Article 1839 of the law. So these rules dictate the order in which the partnership's liabilities should be paid. First, any debt owed to creditors who are not partners must be settled. Next, any outstanding amounts owed but to partners that are not related to capital or profit are addressed. Following that, liabilities related to capital contributions are resolved. And finally, any remaining liabilities related to profit are addressed. It is important to note that these rules apply specifically to general partnerships, and there is a separate process for the liquidation of limited partnership. So now let's jump to the order of liquidation for a limited partnership. So in Article 1863, the provision in Article 1863 establishes a clear order of priority for distributing assets after the dissolution of limited partnership. So creditors, including those owed by limited partners, are given priority. If the partnership agreement does not specify the share of profits for each partner, a limited partner's share will be proportionate to their capital contribution. So this proportional sharing occurs when the partnership assets are not enough to fully satisfy all partners' claims. And now let's tackle the law on corporation. Section 2. Corporation defined. A corporation is an artificial being created by operation of law, having the right of succession and the powers, attributes, and properties expressly authorized by law or incident to its existence. An example of a corporation can be a technology company called TECO. TECO is incorporated under the laws of the Philippines, specifically governed by the Corporation Code of the Philippines. As a corporation, TECO is considered an artificial being created by law. It has the right of succession, meaning that it can continue to exist even if individual stakeholders leave, become insolvent, or pass away. TECO's power and abilities are limited to what is explicitly authorized by law or granted in its charter. So here are the kinds of corporation. A. Stock corporation. A corporation that has shares of stock and can be distribute profits to stakeholders. B. Non-stock corporation. A corporation that is not organized for profit and cannot distribute dividends to members. C. Corporation de jure. A corporation that is legally organized according to the requirements of the law. D. De facto corporation. A corporation that has a flaw in its incorporation but is treated as a corporation in practice. E. Public corporation. A corporation created by its own charter for the government of a portion of the state, like barangay, city, or municipality. F. Private corporation. A corporation formed for a private purpose or performing public functions under the General Corporation Law. G. Corporation sole. A corporation with only one incorporator organized to manage the affairs of the religious denomination. H. Eleemosynary corporation. A corporation organized for charitable purposes. I. Domestic corporation. A corporation formed and existing under the laws of the Philippines. J. Foreign corporation. A corporation formed under the laws other than the Philippines, but allowed to do business in the country. So the advantages of a corporate organization are strong separate judicial personality, limited liability to investor, free transferability of units of ownership, centralized management through the board of directors, professionalism, and easier to sell small amount of stock to raise capital. While the disadvantages of a corporation organization are extensive government regulation, double taxation, and activities are limited by charter and various laws. So what is the distinction between partnership and corporation? A partnership is created by agreement, while a corporation is created by law. In a partnership, partners have unlimited liability, while in a corporation, stakeholders have limited liability. The management of a partnership is shared among the partners, while in a corporation, it is invested in a board of directors or trustees. Additionally, a partnership has no right of succession, while the corporation has the right to continue existing even if stakeholders change. So let's proceed to the solution of a corporation. Corporations can be dissolved voluntarily or involuntarily. Voluntarily dissolution involves filing the necessary documents with the Securities and Exchange Commission without a hearing if there are no affected creditors, but with a hearing if creditors are involved. Involuntary dissolution occurs when a verified complaint is filed with the SEC, and a notice and hearing are conducted based on grounds authorized by law. So these grounds include fraud or misinterpretation regarding the paid-up capital, persistent ultra-virus acts despite warnings, continuous inactivity for at least 5 years, refusal, refusal to adopt or approve by laws, and serious dissension within corporation. So other ways in which corporation can be dissolved include the expiration of their term, the shortening of the corporate term as allowed by Section 120 of the Corporation Code, failure to organize and commence business within 2 years from the date of incorporation or legislative dissolution. Now let's move on to corporate liquidation. After a corporation is dissolved, it continues to exist as a legal entity for the purpose of settling its affairs, but not to continue its business operations. The liquidation process for a dissolved corporation lasts for 3 years. During this period, the corporation cannot extend its corporate life by amending its articles of incorporation. If the corporation has pending legal cases, the stakeholders must transfer the rights of actions to trustees to continue the case. After the 3-year liquidation period, the officer and directors of the defunct corporation may be held personally liable for any unpaid deficiency tax assessment. So that ends with my discussion. Thank you and God bless.